Members of the jury, you, as jurors, are the judges of the facts. But in determining what actually happened and arriving at a unanimous decision as to the facts, it is your sworn duty to follow all of the rules of law as I explain them to you. You have no right to disregard or give special attention to any one instruction, or to question the wisdom or correctness of any ruling I make regarding the law. You must not substitute or follow your own notion or opinion as to what the law is or ought to be. It is your duty to apply the law as I explain it to you, regardless of the consequences. It is also your duty to base your verdict upon the evidence you received and nothing else. That was the promise you made and the oath you took before being chosen by the parties as jurors, and they have a right to expect nothing less. The defendant has been charged by the government with violations of our law. The indictment is just the description of the charges made by the government against the defendant. It is not proof of guilt. The law presumes a person innocent. The law does not require a person to prove his innocence or produce any evidence at all, and no inference may be drawn from the fact that a defendant chose not to testify. The presumption of innocence means that the defendant starts the trial with a clean slate. In other words, I tell you that the defendant is presumed by you to be innocent throughout the trial, up to the time, if ever, you, as a jury, are convinced that the government proved the defendant guilty beyond a reasonable doubt. Unless you are convinced beyond a reasonable doubt that the defendant is guilty, it will be your duty to find the defendant not guilty. A reasonable doubt is a doubt based on reason and common sense after careful consideration of all the evidence in the case. Proof beyond a reasonable doubt is proof that is so convincing that you would be willing to rely and act on it in the most important of your own affairs. If you are convinced that an accused has been proved guilty beyond a reasonable doubt, say so. If you are not convinced, say so. As I told you earlier, it is your duty to decide the facts. In deciding or doing so, you must consider only the evidence received during the trial, including the sworn testimony of the witnesses and the exhibits. Bear in mind that the statements and objections made by the lawyers are not evidence. The function of the lawyers is to point out things they feel may be important or helpful to their side of the case, and in so doing to call your attention to certain facts or inferences that might escape your notice. In the final analysis, however, it is your own recollection of the evidence that controls in the case. What the lawyers say is not binding on you. Do not assume from anything I may have said or done during the trial that I have an opinion on any of the issues in this case. Except for my instructions to you on the law, you should ignore anything I may have said or done during the trial in arriving at your own findings as to the facts. While you must consider only the evidence, you are allowed to draw such reasonable inferences that from the evidence as you feel are justified in the light of your own common sense. I remind you that it is your duty to decide if the government has proved the guilt of the defendant beyond a reasonable doubt. In doing so, you must consider all of the evidence. This does not mean, however, that you must accept all of the evidence as true or accurate. You are the sole judges of the weight of the evidence. In making up your mind and reaching a verdict, do not base your decision on whether a witness was called by the government rather than by the defense. Your job is to consider the testimony you heard from every witness that was called, and then determine how much you believe of what each one had to say. You are here to decide whether the government has proved beyond a reasonable doubt that the defendant is guilty of the crimes charged. The defendant is not on trial for any act, conduct, or offense not alleged in the indictment. Neither are you to be concerned with the guilt of any other person or persons not on trial as a defendant in this case. If the defendant is found guilty, it will be my duty to decide what the punishment will be. You should not enter your considerations at all with respect to that. To reach a verdict, all of you must agree. Your verdict must be unanimous on each count of the indictment. Your decisions will be secret. You will not have to explain your verdict at all. It is your task to consult with one another, and it is your duty to deliberate in an effort to reach an agreement. Each of you must decide the case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. During your deliberations, be willing to re-examine your own opinions and change your mind if you find that you were wrong. Was it?
That was good. That sounded fast. That sounded, yeah.